Okay, I think we can start now. Good afternoon, everyone. I have the privilege of welcoming everybody to this second webinar of the 2000 NLS 2003 Nigerian Law School Class of 2003. This is the second in the series of our webinar. Mr. Mazi Afam Osigwe is supposed to be with us. He sent his apologies. He'll be joining us later. He had to travel. His flight was delayed, but he'll be joining us later. I know Mr. Tobenna Erojikwe was with us earlier as well, and I believe he will rejoin us. I don't know why he has had to go off. I believe he'll be joining us later. We all know the reason why we are here. My name is Adenike Oyalo to begin with. My name is Adenike Oyalo. I'm the Secretary of the Learning and Development Committee of the NLS 2003 and NLS Class of 2003. And for today's webinar, we don't have just a topic, we have a theme, because the theme encompasses the myriad of problems that is facing the legal profession in Nigeria. But before we start, I want to call on the president of the NLS Class of 2003, Mr. Kabiru Akonbi, to give us a brief opening remark before I introduce our members or the members of the panel that will be dealing with today's topic. Mr. Kabiru Akonbi, over to you. Please remember to unmute yourself before you talk. Thank you.
Thank you very much, Ms. Adenike Oyalo. Our esteemed speakers, my Lord Honorable Justice Peter Olabisi Ige, JCA retired, and other esteemed speakers here, fellow alumni. It gives me great pleasure to welcome you all to the second edition of our quarterly webinar series. Today, we will explore innovative solutions for the Nigerian legal sector, a multidimensional approach to rejuvenating the legal sector. As you're all aware, the Nigerian legal landscape is constantly evolving, presenting both challenges and opportunities. Therefore, we are honored to have distinguished members of the bench and the bar who will share their insights and perspectives on navigating the evolving landscape of the Nigerian legal sector. Together, they will explore innovative strategies and multidimensional approaches for revitalizing and transforming our legal sector. From my Lord Honorable Justice Peter Olabisi Ige, JCA retired, to distinguished Mazi Afam Osigwe, Senior Advocate of Nigeria, Chukwuka Ikwuazom, Senior Advocate of Nigeria, and accomplished legal practitioners like Joyce Oduah Esq and Tobenna Erojikwe Esq. Our speakers represent a diverse spectrum of expertise in legal industry. I'm sure you all agree that this webinar is an opportunity for professional development and a platform for collaboration among our community. So we want to actively participate, share insights, and ask questions. Let us engage with our speakers, share insights, and explore opportunities for collective growth and impact in the legal industry. Once again, I extend a warm welcome to each and every one of us. Thank you for joining us, and I look forward to a stimulating and productive session. Thank you very much.
Thank you very much, Mr. President. Okay, I welcome everybody once again to this second webinar. As Mr. President has mentioned, the theme for today's webinar is innovative solutions for the Nigerian legal sector, a multi-dimensional approach to rejuvenating the legal profession in Nigeria. And as I had already mentioned, and Mr. President corroborated, we are all aware of the numerous problems facing the Nigerian legal sector, both in terms of the legal practitioners themselves and the justice delivery, the extremely slow pace of justice delivery in Nigeria. Well, a significant number of legal practitioners in Nigeria are leaving the profession, I guess also partly because of the very slow pace of justice delivery in Nigeria. You go to courts, most of the time the courts are not sitting. Many legal practitioners are extremely poorly remunerated. and that is frustrating them out of the legal profession as well. So you now have so many people, you know, dumping their core law practice just to be property sellers, or to even jackpot out of the country, you know, to go and do menial jobs and out of the country. We want this webinar to offer solutions, you know, innovative solutions that would curb the trend and improve, you know, increase the speed of our justice delivery system. Now we have 5 panelists, legal giants, that are going to provide innovative solutions to the problems that we are facing in the legal profession in Nigeria. We already have 3 of them. We had Mr. Erojikwe earlier. I'll try to get across to him again to see what is keeping him again from rejoining us. Like I said earlier, Mazi Afam Osigwe would be joining us very soon, I believe. He sent his apologies earlier. So we'll start with the people that we have here right now. Let me start. You can say I am biased if you want, but I'll be starting with the only lady on the panel, which means I'll be starting with Mrs. Joyce Oduah. Let me start by reading her profile, you know, to you. So Mrs. Joyce Oduah is a principal partner of Joyce and Oke Oduah LP, a solution-centered commercial and dispute resolution firm in Lagos and Abuja. In 1990, she obtained a bachelor's degree in law from the University of Lagos. She was duly called to the Nigerian bar on the 10th of December 1991 and completed a master's degree program at the University of Lagos in 1997. She is the Vice President, West Africa of the Pan-African Lawyers Union, PALU, between 2022 and 2025. She's the first female to hold that office in PALU since its inception. She's a council member of the Commonwealth Lawyers Association between 2024 and 2026, still ongoing. She is the immediate past General Secretary of the Nigerian Bar Association, the first female after 38 years to hold that office. She's the National Treasurer, or she was the National Treasurer NBA between 2012 and 2014. She's a member of the Federation of International Women's Lawyers, FIDA, council member of the International Bar Association between 2020 and 2022, fellow of the Institute of Chartered Mediators and Conciliators, associate member of the Institute of Chartered Mediators and Conciliators, of Certified Fraud Examiners and Notary Public. As General Secretary of the NBA, she was an active member of all the existing committees of the association. She has under her belt several national and state appointments, including board member, Gurara Water Management Authority 2009, member Law Reform 2007 to 2009, member Lagos State Blueprint Committee on the Continuing Legal Education 2020-2022, board member and director, Legal Aid Council of Nigeria 2020 to 2022. She's the president and founder of Fountain Life for the Needy Foundation, a non-governmental association that provides for the needs of disadvantaged women, children, and youth in Nigeria. She has received numerous awards for her commitment and dedication to the service of God, the bar, and humanity. She's passionate about ensuring women and young lawyers' participation in leadership in the international and national bar associations, the judiciary, corporate practice, and the larger society. Mrs. Oduah believes that young lawyers are the future of the legal profession, and that is why she's committed to ensuring their growth and development as practitioners and individuals. She's the founder of the Agile Legal Professional Mentorship Scheme, a visionary initiative to connect aspiring and young lawyers with seasoned practitioners across the various spheres of legal practice. Mrs. Oduah is married to her law school sweetheart, Mr. Oke Oduah. She's blessed with 4 children, 2 of whom are legal practitioners. One is a graduate of law awaiting law school, and the other is a final year law student. Mrs. Oduah, you're welcome to this session. Mrs. Joyce Oduah, can you hear us? Anyway, let me move on to the next panelists while we try to
Thank you so much. Thank you so much. I can hear you, Adenike. Thank you.
You're welcome. I'm glad to hear that. You're welcome. Thank you, ma'am.
Thank you.
I'll be moving on from her to Mr. Chukwuka Ikwuazom. Mr. Chukwuka SN is a highly esteemed partner in the dispute resolution tax practice of Aluko and Uyebodi and heads of the firm's taxation practice. Mr. Chukwuka's academic achievements are a testament to his unwavering commitment to his craft. He holds a law degree from the prestigious University of Nigeria and an LLM from Columbia University, New York. During his time at the Columbia University, he was a proud recipient of the Harlan Fiske, I hope I pronounce that right, Stone Prize for Academic Excellence, and the Judith R. and Michael Iltoya Scholarship. Mr. Chukwuka is admitted to both the Nigerian and New York State bars. He is a fellow of the Chartered Institute of Taxation of Nigeria. As a specialist in commercial litigation and arbitration, Mr. Chukwuka has conducted litigation at trial and appellate levels on an impressive range of issues. His expertise spans energy, taxation, intellectual property, telecommunications, finance and banking, receiverships, and insolvency. His exceptional legal prowess led to his elevation to the prestigious rank of Senior Advocate of Nigeria in December 2020. Mr. Ikwuazom has successfully litigated several landmark taxation cases, establishing legal principles in the process. Currently, is leading the team representing the firm's clients in some of the largest tax claims in the country. Chukwuka provides critical advice to a prestigious clientele that includes almost all the international oil companies in Nigeria, banks and other multinationals on taxation and other matters. Mr. Ikwuazom is a member of the Nigerian Bar Association section on business law and served 2 terms as vice chairman of its Employment and Industrial Relations Committee. He was a member of the Technical Committee on Conference Planning for the 2019 and 2020 NB Annual General Conferences and served as the chairman. Of the Nigerian Bar Association Lagos branch in July 2017 for a 2-term year that terminated in July 2019. As chairman, Mr. Ikwuazom pioneered several transformative activities, policies, and practices that redefined leadership at the branch. His impactful tenure birthed enduring legacies like the monthly knowledge sharing sessions, which drove meeting attendance from an average of 250 to almost 1,000, prompting the branch to move its meeting from the foyer of the High Court of Lagos State, Igoshere, to City Hall, Onekon, Lagos. His administration reconstituted continuing education initiatives. He was a member of the National Executive Council of the NBA from 2017 to 2021 and has been reappointed to serve at the National Executive Council for a 2-year term terminating in August 2024. Currently, Chukwuka serves as chair of the Building Committee of the NBA Lagos branch. In that role, he's working tirelessly with other members of the committee to deliver to the NBA Lagos branch a befitting bar center that has eluded it for a long time. Chukwuka also chairs the Nigerian Bar Station Securities Agency Relation Committee. Through the NBA SAC, that's the Security Agency Relations Committee, Chukwuka and his team work to foster collaboration between lawyers and security agencies in Nigeria and to reduce incidences of clashes between lawyers and security agents. Chukwuka's result-driven approach and enviable record of service earned him a distinguished award for outstanding services to the bar at the 2023 dinner of the NBA Lagos branch. Ladies and gentlemen, I present to you Mr. Chukwuka Ikwuazom, SAN. Welcome, Leonard Silk.
Thank you very much, Adenike. It's my pleasure to be here. Thank you.
You're welcome, sir. I understand Mr. Tobenna Erojikwe is now back with us. Mr. Erojikwe.
Yeah, can you hear me?
We can hear you perfectly. I just want to be sure before I read your profile. Thank you very much. You're welcome, sir. You're welcome, sir. Now, our next member of panelists is Mr. Tobenna Erojikwe. He's a partner with the Law Crest LLP, a full-service commercial law firm based in Lagos, and he heads its energy, finance, and major projects team. He holds an LLB degree from the University of Nigeria, Nsukka, and was called to the Nigerian bar in the year 2000. He was admitted as solicitor of the Supreme Court of England and Wales in 2004. He holds an LLM in corporate finance law from the University of Westminster. In his over 20 years of legal practice, 10 of which was spent in England, He has held notable positions and played significant roles, including Senior Solicitor, Regeneration, London Bureau of Barnets, Legal Advisor to the London Bureau of Barnets, Urban Regeneration Board, Legal Advisor, Mill Hill East Urban Regeneration Board, and Legal Advisor, London Bureau of Barnets Pension Fund. In the last 10 years, Tobenna has been involved in groundbreaking energy PPP projects and corporate finance transactions in Nigeria. Which is listed as a leading energy and natural resources expert, as a leading energy and natural resources expert by Who is Who Legal, the world leading legal directory. He led the team of the Lawcrest LLP that won the IFLR 1000 restructuring deal of the year for Sub-Saharan Africa in 2020. He's currently a member of the National Judicial Council and very recently served on the Enugu State Government Transition Committee. He's the chairman of the governing board of the Institute of Continuing Legal Education and of the Nigerian Bar Association. He has been a member of the National Executive Council of the NBA since 2018 and was the chairman of the Technical Committee on Conference Planning of the AGC 2022. He has served in various committees of the NBA, including the General Purposes Committee, the Legal Education Committee, and the Finance Committee. He was also the chairman of the Policy Development and Project Implementation Team during the Olumide Akpata administration of the NBA. Mr. Tobenna Erojikwe, you're welcome, sir. Mr. Erojikwe.
Thank you very much.
You're welcome. I'll be reading the profile of...
Thank you very much, my...
Thank you so much for being a member of this panel. I'll be reading the profile of Mazi Afam Osigwe, even though he's not yet here, but he has promised to join us when he's because he was.
I am here. I am here. Joyce is about 5 minutes.
Thank you so very much. I didn't notice that. You're welcome, sir. I hope you had a safe trip.
Thank you. Yes, I did.
Okay. Thank you so much, sir. Okay, so I'll be reading your profile next. So Mazi Afam Osigwe was called to the bar in Nigeria in September 1999. He became a notary public of the Supreme Court of Nigeria in 2006. He holds a Master's of Laws degree from the University of Jos in 2010 and another Master of Laws LLM in Transnational Commercial Practice from the Center of International Legal Studies in Austria in collaboration with the Lazarski University of Poland. In pursuance of his quest to diversify his legal practice as well as deepen his knowledge of alternative dispute resolution, he concluded a face-to-face tutorial at Keble College, Oxford, United Kingdom, and obtained a diploma in international commercial arbitration of the Chartered Institute of Arbitrators in the UK. He became a fellow of the Chartered Institute of Arbitrators of the UK in 2011. He was the chairman of the 2023 Nigerian Bar Association Annual General Conference Planning Committee. He was the chairman of Nigerian Bar Association Abuja branch between 2010 and 2024, General Secretary of the Nigerian Bar Association between 2014 and 2016, member Legal Aid Council of Nigeria between 2014 and 2016, a member General Council of the Bar between 2015 till date, and member of the Council of Legal Education 2015 to 2018. Is a life member of the Body of Ventures of Nigeria. Mr. Mazi Osigwe is a member of the International Bar Association, Nigerian Institute of Management, Chartered Institute of Arbitrators, UK, and the Institute of Chartered Mediators and Conciliators, and an associate member, American Bar Association. He was conferred with the rank of Senior Advocate of Nigeria in December 2020. He is the senior partner of Law Forte, a firm of legal practitioners, corporate consultants, arbitrators, and notary public. He has a special bias for advisory and litigation practice. Particularly, he offers a wide range of specialized legal service in respect of banking and commercial transactions, banking and corporate services, commercial and financial practice, cross-border commercial practice, intellectual property practice, money laundering, and financial crimes litigation. Mazi Osigwe is a prolific writer, discussant, and public affairs analyst. He has presented at many conferences of the NBA and other programs. Mazi Afam Osigwe, Leonard Seki, you're welcome, sir.
Thank you for inviting me. I'm glad to be here.
Thank you, sir. So lastly, I'll be introducing to you His Lordship, Honorable Justice Peter Olabisi. Well, because his profile is so large. We'll just be reading a very brief summary of what he has been up to in the past over 30 years or thereabout, much more than that. So let me start. His Lordship, Honorable Justice Peter Olabisi Ige, was born on the 12th of July 1953 to Pa Ayola Akano Ige and Mrs. Ojeronke Ajoke Ayola. Ayola Ige ni Ojedokun of the Ige Ajala family of Onikeun compound, Iwere Ile, Iwajowa local government area of Oyo State. His educational career started at Baptist Day School, Iwere Ile, between 1951 and 1961. From there, he moved to St. Bernard Catholic Primary School from 1962 to 1967. Due to financial difficulties, he could not proceed to secondary school, but through his doggedness, he continued through evening school after relocating to Lagos State in 1968. He studied through and attended Benevolence High School, Jelegba, Surulere, Lagos, the evening session between 1972 and 1974. He was employed as a messenger in the High Court of Lagos State and became a clerical officer at the Lagos State High Court in 1978. After passing the GCE advanced level, his Lordship gained admission to study law at the University of Lagos. And while at Unilag, he received federal government scholarship for academic excellence for 2 consecutive academic years. That's between 1982 to 1983 and 1983 to 1984. His Lordship went on to the Nigerian Law School between 1984 and 1985, where he graduated, he obtained rather second-class honors upper division. I'm sorry. His Lordship second-class upper division in 1985. It is pertinent to say that from being a houseboy, cook, steward, laborer, messenger, clerical officer to higher registrar, his Lordship began his professional legal career as a state counsel at the Lagos State Ministry of Justice, Alausa, New Secretariat, Ikeja, Lagos from 1985 to 1987. He was employed as a legal practitioner in the chambers of Mrs. Shinkafi Kusamotu, Olojo and Co. between 1987 to 1992. He established his own private chambers, Peter Olabisi Ige and Co., Ojeronke Chambers, from 1992 to 2001. But on 27th of June 2001, he was appointed as a High Court judge, Oyo State Judiciary, from where he was elevated and appointed Justice of the Court of Appeal in 2012. In his 2 decades as a judge and then later a Justice of the Court of Appeal, he was assigned various national assignments, state and federal assignments, which include election petitions, tribunal, committee duties, notable ones, which include High Court Rules Review Committee of Oyo State 2010, Committee on Court of Appeal Mediation Rules 2018, Election Petition Review Tribunal Manual Committee 2019 and 2022. His Lordship is a rare talent in the legal profession on legal matters, both in substantive and procedural. His Lordship is a highly dedicated professional, both in public and private practice, and as a jurist with vast experience in education and administrating justice. In his leisure time, his Lordship enjoys traveling, singing, and listening to indigenous music. He's solemnly generous and is a Christian and Catholic by denomination. He's a man devoted to the works of faith, law, and is a community man. He's married to Princess Eunice Adefunlayo Ige, and they are blessed with children and grandchildren. You're welcome, Your Lordship. Thank you so much for joining us.
Thank you, Adenike Oyalo, for having me. I'm very grateful.
You're welcome. So now, without further ado, we'll be starting off this session. Yeah, we are all aware of the problem we have in the justice delivery sector in this country. Cases are supposed to take maybe a year, 2 years maximum. You have them taking several years before they are concluded. And when they are concluded, judgment enforcement is another very big hazard, as litigants that have actually suffered through many years trying to obtain judgments have to, they are frustrated in trying to enforce judgments. I will start, first of all, by... Okay, before I even start asking the question, let me just set the ground rules. There are rules. Everybody should please mute their mics. It's only the speakers are allowed to speak when to unmute their mics before they speak. If you have any questions, please put your question in the chat box. We'll read the questions out as the proceedings, as sessions go on. And we are supposed to be streaming on YouTube. I'm not sure whether we are. If we are, I will require somebody that has YouTube link to put the YouTube link on the chat box so that other people who are not able to join through this Zoom platform can also join through the YouTube stream, live stream. So anyway, so back to the questions, to the session proper. Yes, we know that there are several factors that are working against the speedy and efficient justice delivery system in the country. We can start by talking about our inadequate and mostly decrepit court infrastructure. For instance, I am aware of someone, a magistrate, who has to be sharing courtrooms with other fellow magistrates because her courtroom literally collapsed. And so we have to ask, in this regard, who are the people that are responsible for making sure that the courtroom, the infrastructure are adequate and they are habitable for judicial officers to work and dispense justice? I'll be starting on that note with you, sir, your lordship. If you can start on that note with us, sir. If you can answer that question, who are the people that are supposed to have, who are the people that have the responsibility of ensuring that the infrastructure in the courts are adequate?
Thank you very much. The person charged with the responsibility of providing infrastructure for court use is the executive arm of government, because they are in charge of capital projects. The pause given to the judiciary is about recurrent expenditure, that is to pay salaries of the union workers and the rest. At the state level, you see that it is the state government that provides money for capital infrastructure like courtroom, court buildings, and the provisions of all the gadgets to be used in the court. So all the court can do through the chief judge of each of the courts is to take their own recurrent expenditure to buy stationaries, to maintain petty things in the court, like buying newspapers for the judges, looking after the official quarters of the judges, repairs, and the rest. But when it comes to provision of these hardcore courtroom buildings, tables, everything, and all the necessary furnitures needed by the judges, whether at the magistrate court, at the high court, court of appeal, or Supreme Court, they are to be provided for by the executive arm of government. And you know that at every budgetary year, each of the courts are expected to forward the expenditure, the capital project they want to embark upon, what it will cost them, the estimate for judges, whether at the magistrate court level, high court level, and so on. So all this has to be approved by the state legislature if it is at the state level, and at the federal level, the same thing. But there are some funds that are being sent through the NJC to the state, and that is just for the maintenance of the judges, the high court judges and court of appeal judges, just to make sure they have all the necessary tools to work in their chambers. But it is not the duty of the courts. When I talk about the court, I mean the head of court and the justices and the staff. It is not their duty to provide infrastructure for the justice system. That is for the executive to do.
Nike, you are muted, Nike.
I'm so sorry. I'd forgotten that I muted myself. Thank you, sir. Thank you, my lord. And so I was saying that you sort of get the impression, the way the CJs of states courts and the CJN sort of kowtow and to the executive arm of government as if they are subservient to the executive arm of government. And yet each of these arms of government are supposed to be equal. In fact, in my opinion, I think that because after the legislature make the laws and the judiciary interprets the law, sort of if there's any problem, the judiciary has the last say. And so in my opinion, the judiciary is even a bit superior to the other arms of government. And yet you see them, I guess because of this issue of the purse strings being in the hands of the executive, sort of behaving as if they are subservient to the executive arm of government. So is it supposed to be so? The situation of things, the way they are, with the judiciary having to run to the executive to provide this and that, is it supposed to be so, sir?
Well, it is not supposed to be so. But if you agree with me, we have three arms of government. Even though they are separation of powers, but they are interdependent, and the Constitution made it so. If you look at some of the sections in the Constitution, I think 2 sections there, it talk about the budgetary provision for judiciary. In fact, it is expected that at the beginning of each budgetary year, the money required for the development of infrastructure and both the welfare of the judges in the courts are to be paid over to the head of the court. But you and I know that for a very long time, the judiciary have been having running battles with the governors of the state so that they will be forced at least to follow what the Constitution is saying. As of today, only about 4 or 5 states can be said to be conforming with the provisions of the Constitution. But running to the executive, it depends on the head of court and those who are in the judiciary going to meet the governor or sitting down with the governor on how to fund the judiciary, to my mind, cannot detract from the oath of office of a judge to do justice to all manners of persons without fear or favor, ill will or affection. It is only those who wish to be corrupted by going to the governors or executive that will be corrupted. You have heard of J.I.C. Taylor, even though you have government in Lagos State, but nobody can pocket the judiciary that time. And even as of today, many of our judges, they stand their ground and they perform their duty to the best of their abilities. And that is why most of the courts are dilapidated. Because if the judges have been going to the executive to bow down for them or to just see themselves as subservient to them, things will not be as they are today. Things will not be as they are. But the judiciary is trying as much as possible to stand on its own lane. And notwithstanding that, at a particular point, they have to at least liaise with the executive arm of government for smooth running of government, because government means executive, judiciary, and the legislature. And it is for the executive and the legislature to know that under the Constitution, the judiciary must be independent for it to be impartial. That is guaranteed. If you look at Section 17 of the Constitution created an egalitarian society where rule of law will thrive, where the justices will be able to dispense justice without fear or favor. So I believe that it is the system that has made it so. But the solution is that maybe through NJC, let this fund be deducted from the money from the revenue of the federation to directly to the judiciary so that each of the states of the federation will have its money contributed from the source, and NJC will be the one to be disbursing such money so that there won't be all this friction or going cap in hand to the executive every now and then. The good thing is that the NJC has now, even for those who have retired, before, those who retired at the state level, they are not able to even assess their gratuity and all the rest. But now, NJC has taken it over. NJC is now the one to pay gratuities and retirement allowances directly to the judges, both at the state and at the federal level. So I believe that with seriousness on the part of the legislature and the executive, things will move better. And let us believe, like I said in the paper I wrote, that the National Summit on Justice, you can see that the president of the country, he gave undertaking that he's ready and willing to do anything that will make the judiciary truly independent, that will provide for equal access to justice within a reasonable time. I think Lateef Fagbemi, the Honorable Attorney General, Lateef Fagbemi SAN, the Honorable Attorney General and Minister for Justice, he too said a lot of things that is geared towards moving away from the past problem. And if you notice too, the Honorable Chief Justice of Nigeria, my Lord Olukayode Ariwola, CJN, GCON, made it clear also that this is the only way by which we can have impartial judiciary that will be bold enough to dispense justice to all and sundry. So I believe very strongly that if there is willingness on the part of the arms of government, it is a very simple and easy thing to do.
Thank you so much, my Lord. Thank you so much. I hope that the judiciary will also try to assert their independence, because sometimes this sort of thing has to be taken. The executive will always want to overrun the judiciary if they have the power to do so. But I'll still on this issue of the court infrastructure, I'll be calling on Mr. Chukwuka Ikwuazom and the rest of the members of the panelists to weigh in briefly on what role they feel that the NBA can play to ensure that our court infrastructure are adequate. Mr. Ikwuazom, you go first.
Thank you very much, Adenike. So I think if we want to call a spade, I'll tell you what the problem is. The problem is that it is not in the interest, the way politics is structured in the country, it is not in the interest of the executive to have a strong, independent judiciary. That's just what it is. Every state executive wants to be able to control the judiciary through the chief judge. And that's why, regardless of the very clear provisions in the Constitution, I think Section 132, and even Executive Order number 10 that was signed by the President, Muhammad Buhari in 2020, most state executives have refused to grant financial autonomy to the judiciary. Unfortunately, because of the nature of the work that judges do, they cannot fight for themselves. So that battle must be fought by the NBA. It has to be fought by the lawyers. And, this thing does not require too much talk. What we really need to do is, as a bar association, to take up the fight and insist that the very clear provisions of the Constitution be given effect. But that's just one side of the problem. Even the judiciary itself needs to do better, because the reality is, I've always made the point that there's a need to separate administration of justice from the administration of the courts, right? That's what you find in developed societies like the United Kingdom. Judges, by their nature and training, are required to dispense justice. They do not have the skills to administer infrastructure in the courts. So, for example, my lord, when he was speaking, talked about the importance of budgeting. Do we have the skills within the judiciary at the different states and even at the federal level to prepare a proper budget? What about maintenance of the infrastructure that we have in existence? So I think that while we fight for the executive to grant full financial autonomy to the judiciary, it's also important that the judiciary, starts to have a conversation around how to build skills by appointing trained court management officials to administer the courts as different from the administration of justice. Thank you.
Thank you, Leonard. I think that was part of the thing that was discussed at the just concluded Justice Summit. Mrs. Oduah, please, let's have your input on this, on the role of the NBA. If you can hear me, okay. Thank you.
Thank you so very much, Adenike, and let me use this opportunity to also thank the president of class of 2003 and all his members for inviting me to be part of this panel. I would like to say that when you want to talk about what the NBA needs to do, we'll first of all say something. Our constitution empower us also to speak on behalf of the judiciary. But what I would like to say is just like what you said. You said something that we have three arms of government. And since we have three arms of government, the three coexist and they must all be independent. Unfortunately for us, the judiciary is the one that the government tramples upon, despite all that have been done, just like my lord said, and also my brother said, Order Executive Order 10 during Buhari administration, and also the sections of the Constitution. The fact is that this had made it so difficult, so difficult. Can you hear me? Sorry.
Yes, we can hear you very clearly. We can hear you.
Yes, this has made it really difficult. You find out that this has really impeded the work of the judiciary. You find out that a lot of things are wrong. Manual recording of legal proceedings, coupled with these inadequate facilities, all only serves, to bring down what we have in the judiciary. I will say that the judiciary needs to be independent, not only independent, but financially independent to be able to do well. My lord said a lot of things, how, money comes from here, from the executive to the judiciary. I think we should be able to ask that this money should be budgeted directly and given to the judiciary. Some people will say, how will they manage it? It's still going to be the same thing. I said, no, I don't believe that it's going to be the same. Because once you have your money, he that wears the shoes know where it pinches. Our chief judges know where it pinches them. So they will know what to do. They will know how to improve on the facilities. For example, now in the country, you have this problem of you go to court today, there is no light and the judges cannot sit. You won't blame them because they can't sit under terrible situations. They can only sit and do their jobs when the situation is very comfortable. For example, we have this bar and bench meeting in Lagos some few weeks back. And what was the problem? You find out that most of the courts in Lagos, they don't sit because there is no light. The light situation has been very bad. But if the judiciary have their money, they won't go cap in hand begging the executive to give them money to buy diesel to be able to run their generator. For example, you see the CJ will go to the governor or the executive to ask for money.
Hello, ma'am.
What is this? You find out that what our people do. What our people do is that they go there, governors, you have a case, we have a case before you, And whoever you assign the case to, if they don't do what we want, you will not be able to get your money. I know of situations.
Hello. Okay, I think maybe we should just move on because our time is
Because it's what they wanted them to do.
Okay, thank you, Ma. Because of the time, I think let me just quickly call on Mr. Erojikwe to just intervene briefly before we move on, because we still have quite a number of things to discuss and time is really going. So, Mr. Erojikwe, please, over to you.
Okay, thanks.
Yeah.
Go ahead,
Thanks
sir.
a lot for inviting me. I'm very grateful to Law School Class 2003, and I must say it's quite an issue at your end. I've heard the interview. Can you hear me already?
You're going in and out. I don't know. Okay.
Okay.
Yeah, your voice is going in and out.
Sorry.
But
okay, I'll continue.
Let's see whether we can hear you better. Go ahead, sir. Go ahead, sir.
I've heard the intervention of I've heard the intervention of my Lord and the intervention of my colleagues who have spoken. I think that I agree mostly with what they've said. It is quite clear that battling, as far as funding of the judiciary is concerned, is the issue of resources and budgeting and also administration. But if you say, you find that the most critical issue here is the people issue. This system that we operate has been known to work in other places. What is the people and the systems? The sector, the one before this one, when Oduah was president of the NBA, it was very clear from the presentations made by the legislators, that is the Speaker of the House himself, representatives, and indeed by the Senate and the Attorney General at the time, and the Office of Budget, that the judiciary itself was not accountable to anybody, any authority, because they refused to present them, defend it. So there is, and I agree completely, monies to the judiciary should be a first-line charge, should go to the NJC, should be disbursed directly to the courts. It has to do with capital expenditure and infrastructure. But fundamentally, we need to think about the judiciary itself accountable. And you see, when you talk about the NBA and what the NBA is around all of this, I think that the NBA as structured today and the way we have made ourselves, we're likely incapable of dealing with some of the problems that we're talking about. Because you see, all the things that we do, a lot of necessary, a lot of not required, we depend and rely a lot on government. So our relationship with government is such that we're not able to challenge the excesses of government or direct the attention of the government to things like decaying and decadent infrastructure in the courts. You know, we're not playing our role. We're more interested in going to get money from government for our conferences, for our events, and all of that. Forget that one of the most fundamental elements of promotion of the rule of law, which is our motto, is to ensure the system of justice delivery is astute and operates at optimal level. We're not able to achieve that because fundamentally our own relationship with government agencies is such that we are not now able to go to government and demand the things that government ought to do, and rightly so. And the NBA has not prioritized over time things that affect the judiciary. Now, yes, there's a lot of talk about compensation, but do we even have a schedule of all the courts in the country, the ones that are not properly, that are struggling with the infrastructure and require intervention? So I think that there's a lot of soul searching that the NBA needs to do itself, and we have to understand that the level of advocacy required to deal with government or institutions It's at a very high level, and it's not one that you will deal with while on the one hand compromising yourself and not being clear about what your demands and objectives are. And just to say that any country that doesn't take its judiciary seriously would find out that it's completely a mess. Whether we deal with judiciary on the one hand as a separate entity from the bar, I would only say that is one arm of government that is exclusively controlled by the legal profession. Take everything around it seriously. Thank you.
Thank you so much, sir. I think you mentioned the issue of data, which I think is very important, about not having the total number of the courts in the country. But because of time, let me have the quick intervention of Mazi Afam Osigwe, very quick. And hold on, sir. Before you answer, I wanted to also lump it with the issue of lawyers themselves employing deliberate delay tactics to delay cases in the country, and now it affects, the reputation of the country before the international community and investors coming to invest in the country. I know that the governments have been busy, going about looking for investors and everything, but when your country has a reputation of not deciding cases on time, it affects the prosperity of the people and the country. So I wanted to take the two together. Mazi Afam Osigwe.
Thanks. I will not be able to use the video because I'm in transit. I'm in the car with some people, but I hope you hear me.
That's fine. We can hear you well.
I'm glad to be here, and I'm glad to be invited by the class of 2003. And I find this conversation very interesting. I always ask myself when we talk about judicial autonomy, financial autonomy as the problem, I ask myself, is it a self-inflicted injury? Is it that the judiciary has failed to use its powers to ensure that the right thing is done? Or is it that many heads of court, and indeed the judiciary has become comfortable to being at the beck and call of the political leadership of the state, and they have also found themselves as being subservient to them? Now, I attended the legal year ceremony of a certain high court in the country, and I left there, and after listening to the speech by the chief judge, which was made in the presence of the governor, I was wondering if the chief judge did not sound much more patronizing than the commissioner of information of that state. So sometimes the judiciary is not willing to take up its constitutional powers. There have been judgments of the court pronouncing on the autonomy of the judiciary. How come the judiciary is not insisting on the enforcement of these judgments? How come we keep crying about this financial autonomy when there are judgments that have affirmed them? And then also, when you talk about the state of our courts, we should also ask questions. How has our various courts fared in transparently managing the money allocated to them, and also putting some of this money for the benefit of the judicial officers? How well have they managed them in building infrastructure, building the human beings that can man this court? We can have the finest courts, but if we don't have the finest men and women with integrity who will man this course, we're making a mistake. And I'll make a quick example from the story of the Chinese wall. For more than 1,500 years, the Chinese wall was able to keep the barbarians out of China. But it took a man who looked like a farmer, giving a bribe to the judge, to the guard who was guarding the wall, for him to abandon his duty post and allow the Vandals to invade China. What am I saying? There are minor things that we are doing wrong that are allowing the wrong things to happen in our cause. Look at the way judges pointed to the bench. Let's regard the spade to merit. Some other considerations are coming in. The courts are giving more judgments and less of justice. So when you talk about these issues, it's as if when you bring money, it cures all the problems in the judiciary. No, you can have a rundown courtroom, as sad as that may sound, that still gives justice, where a person manages to sit under very horrible conditions, but gives justice and dispenses justice timelessly. I understand the imperativeness of having the right infrastructure. I'm talking about what the NBA will do. It presupposes that the NBA can do it alone. NBA can advocate for compliance with the law. NBA can advocate for constitutional reforms that may enhance the standing of the judiciary. But if the judiciary is unwilling to rise up to the occasion, take up its responsibilities, then we will be making idle talk. I heard stories of judges who refused to honor invitations by the governors, and one of such was Araka, chief judge of Anambra State, who was compulsorily retired by the military administration. Yet today, at every political event, our judicial officers are the ones occupying the high table with the politicians. There's a lot of incestuous relationship between the bench and the politicians. such that the judges are too happy. They seem to be too happy to be appointed, to be fraternizing with politicians. And these are also things that go to weaken the bench. We could have this conversation on a broader scale, but because I know there's limited time, I will quickly go to talk about the attitude of lawyers in delaying the pace of trials or administration of justice in our courts. I've always said it, until we become a nation where actions have consequences, until our judicial and disciplinary process in the legal profession becomes effective, we pay lip service to this. And until clients or lawyers who bring actions to court that have no business in court are made to pay the cost of the losing party, or the person who was unduly made to defend himself or herself, we are not serious. Until as long as you consider to say it's against public policy for you to put the cost of litigation on the losing party, will never be serious. Nobody wants to take us serious. And our courts increasingly are not business-minded. They give our judgments and they have an attitude to cases that do not engender confidence, that do not make for speedy administration of justice. A matter from all the facts and circumstances of it requires timely intervention, and a court will adjourn it for 2 months. A court will grant an injunction and adjourn a matter and keep adjourning without entertaining the application to set aside that injunction. And we think anybody will take us serious. Nobody will. The attitude of our judges is the problem. Attitude of our lawyers is the problem. We take up every cases, even cases that we know that ethically we shouldn't take up. We just want the money. We bring all manner of applications, and the courts that judges are also so afraid, because once a person writes a petition, no matter how silly it is, NJC requires a judge to answer. And so judges are gradually losing control of their courts. They cannot control proceedings until counsel don't do it, because somebody will write a petition and say the judge has taken side his bias, even when the judge is trying to control proceedings in his court. We can go on and on and on until we change our attitude, and there's integrity in the men and women who appear as counsel before the court and appoint the right persons, and have proper judicial attitude that ensures that cases go on. Very few people will have confidence in our court. Many cases are being referred to arbitration in foreign lands. Even some commercial transactions have as jurisdictional dispute resolution clause that they will be settled in England, and we are losing money that we can scarcely afford. And we think anybody will take us serious. Hell, nobody will. Throw all the money you can at the courts, and if the attitudes of the men and women who man the courts and those who appear before them, our general attitude to life and things don't change, nothing will ever change. Nothing will ever get better. People, that money we are talking about giving to the generation will end up in private pockets, and the work will not get done. I don't know how much time I have left, but I guess I'll stop here and wait for your next question. Thank you, Erojikwe.
Thank you so very much, Mazi. You know, what you were talking about, it was some part of what I had in mind. And I want to direct the question to His Lordship, my Lord. You know, the costs, there's an instrument of costs that I believe our judges are not using well at all. You know, you have a case, you know, sometimes go from, maybe even sometimes start from the magistrate's court all the way to the Supreme Court. And at the end of the day, you know, cases that shouldn't even have gone to court at all, they go all through the appellate processes, and then our judges or justices award such puny costs. I don't know, some of the costs are actually laughable. So I'm wondering, why is this so? Why is the instruments of costs, which generally are not supposed to be appealable, are not used by our courts to discourage frivolous applications, frivolous suits?
Thank you very much. Yes. Thank you very much. I will say straight away that the blame cannot be situated only at the doorstep of judges or justices. Let us start from the rules of the courts. All the rules of courts, whether at the magistrate court, at the High Court, Court of Appeal, and Supreme Court, they gave room for necessary dilatory process or dilatory methods being taken advantage of by the lawyers. The rules are so cumbersome. Look at any of the rules. Take Federal High Court rules, for instance. There is no place there how many times you can seek for adjournment, whether it is twice or 3 times in a case before it is decided. The problem starts from initiating the proceedings. You have to serve. It will take almost 6 months before the matter will be ripe for hearing. In the meantime, there will be application for interim injunction, which is permitted under the rules all these things have to be looked at. The rules have to be streamlined. All the provisions in the rules that deals with all this delay, they should be taken away from the rules. Because if the rules are not there, nobody will bring application to the court. And these applications are not heard timelessly because a judge has so many cases on his hand. For example, each of the judges in some of the high court, they have not less than 400 to 500 cases. You can check it out. If one is not making it up. So a court that has to manage his diary, already by now, adjournment have reached 2025 in some of the court. Even some appellate court, adjournment have reached 2025 and so on, middle of 2025. Where do we go from there? We have to look at all the rules in all the courts to make sure that all the clogs, all the things that are constituting clog in the wheel of justice, that is justice within reasonable time, are removed from the rules. And let me tell you, the Constitution itself is bad in some area. This is a Constitution that guarantees fair hearing within reasonable time under Section 36(1) of the Constitution. This is the same Constitution under Section 241, 242, and 243 allows interlocutory appeals to the extent that anything that when a judge calls, the lawyer will appeal. When a judge calls, the lawyer will appeal. If he brings application for joinder or to amend and is refused, the next thing is to appeal, either because of nearness to court of appeal or in order to deliberately delay the matter. Then they will say they are going to the court of appeal. The next day they bring application for stay of proceedings. And the Supreme Court has decided that no matter how frivolous an application is, even if it is downright stupid, a judge is duty bound to hear all applications. Mind you, it is not only in one case that you have such thing. You have it in almost all the cases that are before the court. So if the Constitution gives you a right by Section 36 and now take the same right away by giving room to all sorts of interlocutory appeal via Section 241 to 243, where do we go from there? There are cases, the case of Chief S.B. Bakari versus ACB. You have Chief Kotoye and this other person and Saraki. That is where the Supreme Court said that it is a constitutional right of a litigant to appeal any decision of the court. And it is the same court, Supreme Court and Court of Appeal, saying that this interlocutory appeal should be condemned and deprecated. And they've always condemned it and deprecate interlocutory appeal, which can conveniently be taken at the end of the determination of the substantive case. But the lawyers will not wait, either because they want to become senior advocate of Nigeria, they have to go to the Court of Appeal on every issue, both interlocutory and substantive. If the Constitution is amended, yes.
Yes. Pardon me, yes. If I may, let me come in, my lord. I was actually talking about, yes. Okay, we understand that we have a lot of lawyers that are actually filing all these frivolous, applications and all that, but why is the court not using the power to award hefty costs against this lawyer, against lawyers, even personally?
It has always been done, even up to the Supreme Court. Yet they come every now and then. And you find out that in most cases, I want to say this with profound respect, it is some senior lawyers who are always engaged in this attitude. And when you award cost, the next thing they will appeal against it and say the court is biased for awarding punitive costs. And they will even tell you that they cannot award cost against them in a matter under which they have right under the rules to bring application. So this confusion is there. So unless the constitution and the rules are really amended or streamlined, and the judge will have no powers to stop anybody from bringing application. And it is not all of the time that you award cost, but the judges have been given punitive cost in most of the cases. Some have been coming, especially in election petition. You will see award of 20 million, 50 million, and the rest. So it is not really the problem of the court, it's the problem of the system, the process, and the procedure. That is the the problem we have. That is the undoing of the administration of justice. So if we want to move forward, all of us, NBA, executive, and so on, we must sit down together and identify all these things that constitute impediment to free and fair trial, which is fair hearing within reasonable time. Until we do that, we still be having this problem. For example, in the Court of Appeal, so many appeals are lying fallow there. Many lawyers knew that they have appeal in the Court of Appeal. They won't file their briefs. They won't file their application or whatever. It is when the appeal is struck out, they will now bring the application to restore the appeal. And they'll be making all sorts of noise that the appeal was struck out without informing them, without this, without that. So many things. Luckily, your president, Tabiru Akebi, works in the Court of Appeal. He knows what I'm talking about. So the problem is not with the justices. The problem is with the litigants and the lawyer. Because some lawyers, in some juicy cases, they want to delay, maybe to make money or whatever. The whole thing is there in the open, and anybody can see that. So I would say, with the greatest respect to all of us, that this is the time for us to actually come together and look at all the rules of the court once again and take away all those rules and order that constitute impediment to smooth administration of justice. The same thing with the statutes establishing each of the courts, that is Federal High Court, State High Court, everything. Let us look at them holistically. And the constitutional provision should be amended. If interlocutory appeal are done away with, honestly, we will have achieved 50% progress. Because if you go to the courts today, all high courts, you see them going to Court of Appeal, and they come and be boasting to the judge, we have filed a notice of appeal. Your lordship cannot proceed with this matter. And of course, the judges who want to have brush with the Court of Appeal or Supreme Court, because there are decisions that says the judge is impertinent, the judge is this, well, he has not had this, he has not had that. So we have to be fair to one another. We, the bench, the lawyer, and particularly the two of us, and the other stakeholder, we are the one that have these problems on hand. Let us together solve the problem. Let all of us give in part of our rights so that we can have good rules of court. So if we have good rules of court that does not allow for necessary adjournment and so on, and for dilatory procedure, surely the judges are ready to do their work. The court is even overburdened by all sorts of cases, and we don't have enough judges and justices in all the courts.
Thank you so much, my lord. I'll still stay with you on that. No, from the high courts to the Court of Appeal, the judges are overburdened, like you have said, my lord. So what role do you think technology has to aid, even when we're in the absence of more judges more justices and justices being appointed to fill the gap? What role do you think technology has to play to aid, the speedy delivery of justice? We have AI that can probably do research and maybe record proceedings who do you think should champion, the deployment of this technology to come and fill some gap?
Yes, I'm very sure and I believe very much that technology will help a lot to ameliorate all these problems. So if we, for example, in filing of processes, we now have e-filing in some courts. You can sit in your office and file process. Then believe that has always constituted themselves into another area of impediment. They can now serve somebody through the person's email or through his SMS and so on. The Supreme Court has said that the service in such situation is valid and proper in the circumstance. For example, in the Court of Appeal rules, a lot of innovations are now in it that brought in technology in terms of filing your record of appeal, in terms of how you must move. And we have fast-track practice directions in the Court of Appeal for some particular cases, wherein the number of 45 days or 30 days to file brief of argument are reduced drastically. So I believe that if technology is deployed to administration of justice, if you do away with long hand, you do away with all these unnecessary enjoyment, and AI that you suggested, it can be adapted. It can be adapted to suit our purpose. It can very much be adapted to suit our purpose. So many of them, for this justice delivery system, you have already brought them out in the concept note that you attach to your invitation. You have really identified the type of technology that we need to aid administration of justice. But the problem is this: who will bail the cat? Who will fund it? Do we have constant electricity supply in this country? Can the court actually maintain and sustain this technological development into administration of justice? Because they require money, they require training, they require the judges too to be computer literate and to be trained both within and outside the country. So how do we do it? Who will provide the funds in a situation where you don't have electricity? And electricity is one of the major factors that can aid administration of justice. If the judges cannot sit and you put computer there, it cannot be used because there is no light, and you have generator that will work 15 hours a day. It will pack up and we're back to square one to the same problem every now and then. This is now 1,500 naira or so. Petrol is about 1,000 something. Which court can cope in such a situation? At least some court will need no less than 25 million naira per 5 days to run the court, and that will be from 9 to 1 o'clock, not even for the whole day. So it's not possible. Then judges too, they don't have light in their houses. And the generator they gave them, they cannot maintain them. Some of them are forced to buy a better pass my neighbor because they cannot maintain the generator given to them by the government. So where do we go from there? Unless we first of all lay foundation for these technological innovations and infrastructure to be in place, and we provide enough funds to maintain them, train adequate number of personnel to operate them, and to aid the judges, there is no way they will work for us. I'm sorry to say. The first thing should be done first.
My last submission is really scary. It's looking as if there is no solution to the problem, because the government is...
There is solution.
The problem is talking about being almost going bankrupt, and yet we're talking about solutions that require a lot of money. I guess we can spend the whole day talking about just this topic alone. But let me go to NLS Chukwuka Ikwuazom. We're talking about another major problem that we have is with enforcement of judgments. Enforcement of judgments. A lot of litigants, after getting, spending years in courts and then getting the fruit of their judgments, besides garnishing that is a bit simple, not so expensive, every other form of trying to get the fruit of your judgments, execution of judgments is frustrating for the average litigants. What do you think can be done in this regard? And I want other members of the panel to chip in briefly on that as well. But let me start with you, Mr. Ikwuazom, SM.
Hello. I didn't get, sorry.
I can hear you now.
My internet was fluctuating. I didn't quite get the question.
Okay, so I was talking about enforcement of judgments, litigants being frustrated. I had several cases that we had finished, we got judgments, we levied execution, but we spent so much money levying execution, and then the assets seized are rotting, at the premises of the High Court. At the end of the day, when they even sell part of the assets, the money they sell it for, the money they are giving to us is way, way below the amount we spend levying execution. What do you think is the way out for litigants, after going through years in court, getting the fruit of their judgments? Hello, sir. Did you hear me? Let us see.
Hello, can you hear me?
I can hear you now. Go ahead, sir.
Okay. Before I answer that question, I think it's important for me to weigh in on the issue that the Lord and Afam Osigwe have spoken about, which is essentially the absence of a proper cost regime, which has meant that litigants and their counsel have thrived in dilatory tactics. It's very concerning, because when you look at the plenitude of powers that the Judex possesses, those powers should put a judge in control of proceedings in a court. But what we find is that it's not that the rules of court do not make ample provisions. For example, the High Court rules in Lagos State have a clear provision that cost should be on a full indemnity basis. So the legal framework for that exists. But what you find is that, there appears to be some misconception of what the objective of an award of cost is. I did a matter in court at the High Court of Lagos State, which I genuinely believe did not have any business coming to the court. After we won, I found a proper application, and I provided evidence of the costs that we had incurred, in defending that frivolous suit. And what the judge said to me was, Mr. Ikwuazom, you should be happy that your client won. Why are you asking for this humongous cost? And I was trying to explain to the court that, look, in this instance, the cost is not punitive. The cost is restorative. If I have been brought to court to defend a matter that I didn't have any business defending, then there's a cost element to my defense of that suit. And someone has to bear that cost. Someone has to bear it. So it is sentiments like, oh, but you have gotten what you wanted. Why are you asking for cost? That's what continues to encourage people filing frivolous matters in court. And then that, to a large extent, contributes in the delay that we see in the court system. Then I'll go to the question that you asked. So a lot of the issues we have in administration of justice are administrative. to be honest, right? Because, you know, you go through litigation and you get a judgment. And the law is clear on what steps that you can take to enforce the judgment that you have obtained. Now, if you want to do execution, as opposed to maybe filing third-party debt proceedings, what we call garnishee proceedings here, you want to do execution. The first obstacle that you encounter is the length of time that it takes for you to even get a certified copy of the judgment that has been delivered in your favor. And then when you get that, all the administrative things that you need to do within the court system, and even going to the police to get police assistance to enforce, it's become a whole, what's the word now? It's become a big industry that's plagued by corruption, right? You go to the police, for you to get a police officer assigned to you, sometimes they ask you to pay sums of money that even exceed the amount of the judgment. And then even when you levy the execution and all the assets are brought to the court, you're not able to dispose of them because maybe an application has been filed. You know, the whole process of interlocutory applications and, you know, applications that are filed post-judgment, most of the time, after execution has been levied and the assets have been brought within the court premises, what actually stands in the way of the sale of those assets to realize the judgment sum will be applications that are pending at the appellate court. And we all know, because we know the length of time that it takes for a simple application pending before the Court of Appeal to be decided. You know, at the end of the day, when all the obstacles are taken out, you now find out that, like you said, the assets that have been seized in the execution of the court judgment are worthless. So what I think that we need to do, and again, it goes back to the point I made earlier about drawing a clear line between administration of justice and administration of the courts, right? If we have a competent, knowledgeable workforce that deals with other issues that the courts are concerned with, other than administration of justice, which, by the way, I think should be the primary focus of the judges. And then you get people who are skilled and trained to handle these administrative aspects of adjudication. That's when you start, you know, you're able to start to deal with some of these issues. Until we do that, we're going to continue to face these issues and these challenges. So whether it is the sheriff's section in the high courts, everything, we need to sit down and think about how to, you know, revise and review the work that all these administrative staff in the court system, the work that they do. Until we do that, we'll continue to grapple with these issues. Thank you.
Thank you, Leonard. But what do you think are the innovative solutions that, you know, you can suggest, you know, towards enforcing judgments? Because, you know, the theme of today is innovative solutions. So we're thinking of something that is not something that we've been doing before, but something that maybe are being done in other jurisdictions that we can also, you know, bring to the country.
So one thing that I think I will suggest is, if judgment has been delivered and execution has been levied, first and foremost, I think that within each level of court where judgments are enforced, we need to have a very clear process for enforcement. So if you have the court bailiffs, the court sheriffs, we need to have police officers that are attached to the court to avoid the current situation where when you get a judgment, you have to take that judgment maybe to the Lagos State Police Command, and you start to negotiate with them to give you police officers that will accompany you. We need to have a situation where you have police officers that aid enforcement of judgments that are attached to the courts, so that once you're done processing the judgment that you want to enforce, then from the group of police officers that are stationed in court with the specific function of aiding enforcement, you get police protection. So that will cut out the need for you to go to the Lagos State Police Command, for example, and start to negotiate with them to get officers that will accompany you do that enforcement. That's number one. Number two is that once enforcement has been done and assets have been seized, even if there are applications that are pending, there is no reason why those assets cannot be converted to cash. And then that cash can be put in an account, in an interest-yielding account, pending when all the applications relating to that enforcement have been decided. That will avoid the current situation where assets are seized and left at the premises of the court for years, because parties are fighting with respect to applications that have been filed post-judgment, with the fact that after those applications have been determined one way or the other, you come back and you find out that the assets have been rendered useless. If those assets are converted in cash, then you preserve them. And whichever way those post-judgment applications go, whoever wins will have something to fall back on. And then we need to be a bit more pragmatic about litigation in this country, because what happens at the moment is that, litigants and their counsel do not cooperate and collaborate with a view to, making sure that the business objectives of litigation are achieved at the end. So if I am representing a client and I want to levy execution, or execution has been levied against my client, why should I not have a conversation, enter into a conversation with opposing counsel to say, look, let us not, both parties are interested in the preservation of these assets. What is the best possible way for us to preserve the assets, other than leaving them within the premises of the court for the elements to be hitting on them, and at the end of the day, they become valueless? So that level of collaboration between counsel and parties is very important. So these are some of the things that I think we can do to address the present challenges that we have. Thank you.
Thank you so much, Silk. My Lord, just one last question, because we are really, really running out of time, and we are just dealing with just the first part of the theme that we have for today. So very, very briefly, my Lord, if you may, if you can. Well, we have a question in the chat box. Somebody, Miriam Ahmed, said you were part of the ADR committee, rulemaking committee for the appeal courts. And so what he said concerning the acceptability of ADR and dispute resolution at the appellate level, what do you think can be done to promote it? You talked earlier about dates being given till 2025. We are still in 2024. So how do we encourage ADR at the appellate level? Please, briefly, my Lord, because we still have many grounds to cover.
Yes, thank you very much. Well, ADR is one of the very easy way to resolve all these problem of delay in administration of justice. But it requires the cooperation of the litigant and appellant, if it were the Court of Appeal, the appellant and their counsel, the appellant and the respondent, rather. Once they agree to go to ADR, we just make an order sending them there and to come back within 60 days. At times, it's not up to that. At times, it can be 40 days. At times, it can be 30 days. And most of the time, they succeeded in resolving the issue among themselves. So the ADR in the Court of Appeal is two ways. The parties themselves, the appellant and the respondent and their counsel, they can initiate it and ask the court to give them that opportunity. Then the court too, when we see that it's monitoring something or something they can just resolve through ADR, we refer them to the mediation center, which is headed by a justice of Court of Appeal, serving justice Court of Appeal. And happily, in all the courts, all the high courts, they all have this ADR window. It is there in all the courts. I think maybe what the court should do is to encourage, because there is this provision in the law of all the high courts, that the judges can encourage settlement. They can ask them to go and try their hand on ADR. And I believe that by going to the ADR, some of them will not come back for trial. They will just bring in the term of settlement agreed within themselves to be entered as the judgment of the court. So it's one of the cheapest way to acquire or to access justice in any court.
Thank you, my lord. I think let's move swiftly from the...
And if I can weigh in on the enforcement, please. If I can weigh in on the enforcement.
Very briefly, my lord. We are running out of...
On the enforcement, I agree entirely with the Lanes, I agree with him. But the Sheriff and Civil Process Act and the provisions of the various rules of court has to be amended to enable the court to make that order that, like vehicles or anything rotting away, they should sell them even before the appeal or the matter is disposed of. They should sell them and put them in an interest-yielding account so that whoever wins at the end of the day, we go and collect the money instead of allowing it to lie fallow and to rot away within 5 or 6 years that the matter will take in court. But let us streamline the Sheriff and Civil Process Act and the rules of court to enable the judges to actually be in charge of such a situation.
Thank you so much, my lord. Your conversation, your suggestion will be very controversial. Let's just move on because of time. Now, my next question is to Mazi Afam Osigwe. You are the chairman of the Remuneration Committee, and there are so many legal practitioners, especially the younger ones, that are leaving the profession because of really poor remuneration. What has your committee done in this regard? What have you found?
Your question exposes the misunderstanding about what the Remuneration Committee is about. The Remuneration Committee is not about fixing minimum wage to be paid to lawyers in private practice. The Remuneration Committee deals with the issue of what lawyers charge as remuneration for legal services rendered to clients. Now, if you look at Section 15 of the Legal Practitioners Act, which was the basis for making that order, it only empowers the Legal Practitioners Remuneration Committee to fix charges that lawyers can pay for their services and what kind of deposit. So the issue of what people can be paid and the reason why lawyers are leaving the profession is outside of the purview of our committee's work. And I thought I should make this clear. But I also want to say that every profession would witness a large exit of members in a period of economic decline, in a period where people do not see hope, in a period where people do not see any mentorship by those who have gone before them, where they feel that those who are their seniors are not caring enough, are not giving them room to grow themselves, or that the opportunities are becoming fewer and fewer. It is not limited to the legal profession. But I dare say that if we want to come to the conversation about minimum charge in the bar, we must first of all admit that no law allows any of the bodies or committees or even the NBA itself to fix the minimum charge. I've heard arguments about people saying that the General Counsel of the Bar can, in exercise of the power to make rules of professional conduct, fix this. And I dare say I do not agree. The Constitution is clear that the power to make minimum wage is vested in the National Assembly, and it has made the National Minimum Wage Act. The legal profession cannot be exempt from it. But we can, as an organization, NBA, say within us, let NEC fix minimum wage. But this can only be binding in honor. People will only be required to honor it or then not honor it. But it would also be a good baseline for young lawyers getting into employment to know on what basis to negotiate or what law firm should be as a guide for us to. And that we need to have that conversation because the NBA should work towards fixing that minimum wage, which will be more like a suggestion for people to either apply or not to apply. But there should be such a conversation. Beyond also fixing minimum wage, we should also look at what workplace policies the NBA making, sexual harassment policies the NBA making, and so many other policies. So the remuneration is very important. And when we also talk about remuneration, let us also remember that more than 60% of people who are called to the bar never get a job. So when you're talking about remuneration, it presumes in this context in which you have asked a question, it presumes that most young lawyers get jobs. The problem is that many of them don't have the employment, and we should talk about creating opportunity for them so that those who are not able to get employment should be able to practice and apply the remuneration order and use it as a base for charging, so that even if it is one service they render to clients, they're able to charge enough to sustain them, even in the absence of a job. So the remuneration order is much more important than any other thing, because if we continue to drive the awareness on it and enforce it and insist on compliance with it, and the young lawyers, whether in employment or not, are able to earn more, law firms are earn more, they'll be able to take better care of their lawyers. So remuneration from that point becomes the wage, the returns we get for rendering services to people, not what we pay to our younger ones.
Thank you
because
so
of
much.
time, and I don't know how much time I have,
Yeah,
I will stop short for unless you want to ask me another question.
You don't have any
but I
more
know
time.
that others spoke for longer periods than I did, but it's not important.
You don't have any. Thank you so much. I stand corrected on the work of the remuneration committee. Mrs. Oduah, do you have any intervention on the way the legal practitioners are leaving the profession?
Hello, my dear. Yeah, thank you so very much, my dear. Adenike, like I said, I'm at the airport now. I'm about leaving. I'm moving in, but I just want to say one or two things before I leave, and to thank you all for this program. I really enjoyed my stay here. One, I want to talk about, we're talking about frivolous cases and cost. I want to go beyond that. That is not just frivolous cases. There are times we have some good cases, but the fact is that the plaintiff do not take their cases serious. I have a case that I'm handling at Kwali. It was when that case was assigned, and we are the respondent in the case. And I was asking, where is Kwali court? Any lawyer in Abuja that I ask where is Kwali, they will say Kwali is very far, very far, very far. And you'll find out that we'll travel all the way from Lagos, from here down to Abuja, from there take another trip to Kwali. And you can't believe what happened. The plaintiff themselves, they will not be there. Once, twice, thrice. Then the next one, we just ask the cost for cost. And how much cost did they give to us for traveling all the way from Lagos down to Abuja, then Kwali? Not even Abuja. If it's just Abuja, that would be excellent. But to Kwali, lawyers that are in Abuja know where Kwali is. Whenever you mention it, they will scream. He gave only 50,000. And to me, that was not enough, because we came all the way from Lagos. The lawyers came all the way from Lagos, accommodation, and then you gave 50,000. That is not good enough. I think when cases come up like that, and a plaintiff is not taking his case seriously, what they should do, they should give, what should we call it, punitive cost that will make sure that next time they will be in court. And I also want to join my voice in what my learned friend Ikwuazom SAM said, and my lord, in respect of goods. You mentioned something that after getting a judgment, execution, and the goods will get wasted. Yes, it happened. And we had this bar and bench meeting. I would say that was a wonderful meeting, because Lagos have looked into it. The chief judge was there, and he mentioned it is that what he's going to do, they are going to come up with amending the laws or the rules of Lagos State to say that, look, once a judgment is gotten and we know that these goods are going to depreciate, that they are going to sell, and immediately they sell, the money will be put in a interest generating account, so that whenever the judgment is gotten, these things will not be wasted. And I know that other states also will pick that. So with this, and also I want to say something about my brother's committee, the remuneration committee. The remuneration committee. I want to say that we have the legal practitioner remuneration order, which has come to stay and is a wonderful one. I want to say there are two things that we have from this that you can get from, two benefits. Most that is very important. One is that first, it ensures that practitioners receive equitable remuneration for their valuable services. Now you find out that when your client wants to complain, you just show them, and they have no choice. They will pay. They pay. I've used it, and it has really helped. And then the second one is that it empowers law firm to set more favorable rates, thereby enhancing workforce, enhancing the remuneration package for our young lawyers. Because you can charge more, you will be able to pay more. And that's what we are doing now. Who are the critical part of our workforce? The young lawyers have to be taken care of. And that is what we are doing. And thank God for this remuneration, the legal personal remuneration order. It has really come and is of help. And we are charging where we should be able to pay our young lawyers well. Not only the young lawyers, even the senior lawyers working with us, we need to pay them well. So I want to say thank you, Nike. Thank you, class of 2003, for a very wonderful seminar. I'm off now, my Lord. I greet you, my colleagues.
Thank you so much, man. Thank you for honoring our invitation. Thank you. We appreciate you. Now, let me move on to Mr. Tobenna Erojikwe. You're the chairman of the Institute of Continuing Legal Education, and the ICLE is doing an awesome job in that regard. I've attended many of the trainings organized by the SBL particularly, so I know the work that they are doing in that regard. But I want to know, in what way, what kind of trainings do you think the ICLE, for instance, assuming maybe you're the chairman anyway, so you have the control, that the ICLE can organize profitable trainings, that can expose lawyers, both the young and the not so young, to profitable areas of law, of legal practice, the innovative ones that can help lawyers to stay in the profession. Mr. Erojikwe.
Yeah, Nike, thank you very much. So I'll start first by quickly saying that the earlier commentary or the earlier conversation about compensation on a full indemnity basis is something we have to take very seriously, especially as various rules of court, if not all of them, make provisions for this. I mean, you were talking about what is obtained in other countries in the world, and I practiced in England for 10 years. One of the most powerful tools is what we used to call the Part 36 offer in England. And clearly, when you make even in a case where there is a dispute as to the amount of settlement in a particular matter, say in personal injury or clinical negligence matters, and the claimant or one party makes an offer that is lower than the other party, and you have what you call a Part 36 offer, which is just put in an envelope the amount you've said it is, which puts, and you serve it on the judge. The moment the judge makes an award and looks in that envelope and sees that you had made an offer that would have stopped the matter from going on with to litigation, and the full indemnity cost is awarded to you. So I think that we should take it very seriously. One of the deterrents from litigation in England is the fact that when you lose the case, the other side will pay the costs in most cases. So we need to think about it very carefully. Then moving on from that, I completely agree that the issue of enforcement of judgment is an administrative matter, and that we should have well-trained enforcement officers. We should actually amend our rules to have that, and ensure that those enforcement officers sell the goods as quickly as possible and place in an interest-yielding account that has been said before. On the issue of remuneration, I think the NBA during the administration of Olumide Abata did a very seminal work as far as the minimum wage was concerned. And what it did was to look around the country and make inquiries as to what the living wage for professionals, lawyers, should be across the country. And there was an extensive reporting there, about 126 pages, and then it went on for review by a white paper committee. I would always make reference to the resolutions of that white paper committee. And the reason why I make reference to that particular white paper is that it's symptomatic to every other thing that happens in our profession. We know all the solutions. The problem is, are we willing to implement it? If you listen to the conversations we've had here today, from my lord to my brother Chukwuka Ikwuazom and Afam Osigwe, you will see that it looks like we're all throwing a blame game, right? It's a people problem that we suffer. So when you come to, Mazi talks about who has the power to set the minimum wage. And I'm saying that even the minimum wage in Nigeria itself is not being adhered to by lawyers. Lawyers who employ others are the ones who don't pay payee. They don't follow all the other statutory requirements like group insurance, like pensions, payment of pensions or health insurance, and all of that. Those are statutory things. Those are things that we can actually seek to enforce. And I think that indeed the minimum wage can be made part of our rules of professional conduct, just like we have made the remuneration order. I think the argument is the same. And when you come to the MBA ICLE, I will say this to you. Okay, first track back a little. When I was invited by the IBA to speak about the issues of qualification and post-qualification requirements, my view was that in Nigeria, we don't have a post-qualification training regime like you have in other countries of the world that then ensures that lawyers are properly trained and equipped. So you finish from the university, from law school, and you're allowed to open shop almost immediately. This doesn't happen in most places in Africa or elsewhere in the world, because what it means is that the post-qualification training that you should get, that should actually teach you the nuances or the basic things, and some call it privilege or training contracts, we don't have them here in Nigeria. We don't have legislation that protects continuing professional development in Nigeria. So when we talk about ICLE or CLE, what we're doing at the ICLE is innovative, it's unique. It's not done anywhere else in the world, because we've had over 200 training sessions that are offered to Nigerian lawyers for free by the best of the best in the world. And what you need to practice, as you would agree, is the knowledge in every area. So if you get the best people, we've had trainings on blockchain, on AI. We even got MasterCard Foundation to train Nigerian lawyers on AI at a cost of $200 per head. We have trainings on entertainment law, on all sorts of issues. And also on business development and management. So those are the kind of things. And we've also now started a 700 man mentorship scheme, which is aimed at helping people take what they have learned from the training sessions into the field so that they have real-time guidance. And that's actually a way of sort of ameliorating or filling the gap that the lack of post-qualification education training has created in the legal community and the market. So with that mentorship scheme, we have subject matter specific areas where you have mentors on a virtual platform guiding people and trying to get them, teach them what to do and what not to do in particular instances. We've also made sure that the over 200 training sessions have been placed on YouTube, and now we're building a comprehensive repository. And I don't know where else, and that is what, because in other countries of the world, you have what you call the Bibles, but we've gone further than the Bibles, which is just a text that guides you in that area to get a footing, to invite experts in every area that is imaginable, right? From oil and gas to finance, areas that were exclusively the preserve of certain elite firms in this country. And I would shock you by telling you that in England, for instance, you have only 30,000 litigators, and you have 210,000 transaction lawyers. So if you look at the trainings we've had at the ICL, you see that we have trainings on data protection, on blockchain, on intellectual property, on digital rights, etc. Because most of the income that should come to Nigerian lawyers that goes to foreigners also go to them because we don't have expertise in some of the areas that can actually expand and extend the pot. Finally, I think that if you're looking at growing the earnings of lawyers, you have to think about it from a holistic perspective. The remuneration order is there, is one arm. Ensuring that lawyers who come into the profession are adequately compensated and trained and encouraged to move on is another arm. Creating an access to finance regime like what I did when I was chief advisor to Abata, which was to negotiate a 9% interest rate of borrowings of up to 2 million naira. Creating access to libraries, creating access to tools of practice, all of this put together and more are the things that we need in our profession to move forward. And I dare say that we have resolutions for all of these things. It's a question of the political will and the determination to see them through. Thank you very much.
Thank you so very much, Mr. Erojikwe. Well, our time is fast spent, so we're going to be moving very fast now because we have just a few minutes left to go. But somebody asked a question in the chat box about what the MBA is doing, because one of the problems that we have that is sort of bringing down the reputation of lawyers is this issue of money laundering cases against lawyers and all that. So somebody is asking what the MBA is doing in the fight to help in the fight against money laundering and terrorist financing. So I don't know whether Mr. Ikwuazom, within just a minute, if we can take that on.
Well, let me observe that the questions that you have put to me have been questions. So I was expecting that, having gone round asking my brother Tobenna and Mazi questions around the committees that they chair within the NBA, that you will do the same thing to me, because I'm not part of the current leadership of the NBA, so I'm not in a position to tell you what the current leadership of the NBA is doing with respect to the money laundering issue. What with your, sorry.
I'm sorry, maybe I should rephrase that question to now say, assuming you find yourself at the helm of affairs at the NBA, what would you do to show up the image of lawyers, especially with regards to money laundering activities?
Okay, I mean, that's a better question. So let me tell you my understanding of the problem. The reality is that the confidentiality that exists between a lawyer and his clients is one that is fundamental to the discharge of the duties of a legal professional, right? The law has taken the view that it is important that communications between, or dealings between, a lawyer and his client are protected by privilege. But there's a larger issue, which is the need to keep society free of crimes, right? So if there is reasonable suspicion that transactions between a lawyer and his client actually infringe or breach the law, what should be what should be the right balance between, you know, protecting that confidentiality and ensuring that laws are not broken? So for me, what I think that the conversation I think we need to have is, what are the minimum measures that the law can take or impose to ensure that lawyers do not exploit this confidentiality to perpetrate crimes? I do not subscribe to what the government is trying to do at the moment, which is to subject lawyers to regular regulation, you know, asking lawyers to maybe submit or subject their accounts to public scrutiny. While I do not subscribe to that or support that, I feel that it is important. It is very important that a system is put in place to ensure that while rendering services to their clients, as much as it is important to protect that confidentiality, that is not exploited to commit a crime. So I think that within the profession, and one of the challenges I see with the legal profession in Nigeria is that, you know, law firms are not adequately regulated. They are not adequately regulated. So if the way I see around what is happening at the moment is that we must put in place, you know, a system of self-regulation by the profession of the activities of legal practitioners and law firms. If we do that and we're able to, you know, enforce those internal regulations appropriately, then there will not be any need for society to come and regulate us, which is what's happening at the moment. So that's my take on the issue.
Thank you so much, Leonard Silk. And I felt that question was appropriate because I noticed that you were you had a role with security agencies, you know.
Adeleke, I think I should come in at this point.
Well, anyway, sorry.
Adeleke, I think I should come in at this point on this issue.
Okay, please.
I think
the point.
No, don't always make my own contribution brief, please. The point has to be made. Please, let me go on. The point has to be made. The point has to be made that in 2012, NBA instituted an action challenging Section 5 of the Money Laundering Prohibition Act 2011, which required lawyers to make returns to the SCUMO, to the NFIU and EFCC, which was then domiciled in EFCC. And NBA successfully litigated that matter up to the Court of Appeal, and the matter is at the Supreme Court. And the Supreme Court, Court of Appeal held, both courts held, that lawyers cannot be regulated for the purposes of divulging information obtained from their clients. And as held in the Canadian case, where the Canadian Federation of Law Societies challenged similar provision in the Canadian law, the court, in finding for them, absolved them from such responsibility because the Law Society had their own internal measures. And so the point has been made that NBA has gone ahead to put in place those internal measures through the General Counsel of the Bar. If you read the 2023 Rules of Professional Conduct, it has made copious provisions of what lawyers and law firms should do. And it has a committee that supervises and returns that lawyers should make. No matter the confidentiality of our legal practice, we owe a duty not to use our services to aid the commission of crime or to aid money laundering. And there are provisions. And so there is know your cost, know your client, just the same way banks do it. There are questions you must ask a client about his source of income and the source of money he's paying you and why he's paying you such money. And you to account for kind of money you have. If you look at the Money Laundering Act 2023 and Process of Crime Act 2023, both of them have limited the level of confidentiality a lawyer enjoys in rendering services to clients. So we cannot hide under confidentiality and shirk our responsibility of complying with money laundering requirements. So all of us should do well to go and look at that Rules of Professional Conduct 2023. And secondly, there's a committee to be set up by the NBA to superintend this. And NBA should set that committee in place because NBA must be seen to run a clean house. We cannot insist that certain laws should not apply to us and then fail to comply with measures and ethical standards which stand us out, which make people take us serious, which make people believe that in our dealing with clients and in receiving and handling monies on behalf of clients, we have taken all legal steps to ensure that the proper things are done. I thought I should make this intervention because we're making it look as if there's no provision in the rule and we shouldn't be questioned and we can do as we like and hide under confidentiality. No, we can't. We are part of the society and we have a duty to ensure that our services are not used to aid or advance the commission of crimes. Thank you so very much.
Thank you so much, Mazi.
Nika, do you think I can intervene in that one too? On that one,
I think I'll be staying with you because we are almost at the end of the webinar. I'll be staying. Mr. Erojikwe, you want to add something to that? You want to intervene in that on that question?
Yeah, let me make it very quick and very short. I mean,
I hear what you 30 seconds, please.
Yeah, I've heard the Chukwuka's views and I've heard Mazi's views also, and I find them quite illuminating. I mean, when I was in England, the poker was very clear. Lawyers are gatekeepers. That's why they are an interest element in any money laundering or financing situation. So I always wonder, we're talking about rules of professional conduct. If you look at our rules of professional conduct, even the MBA itself does not put machinery in place to effect those rules. So the question I ask of the MBA and of lawyers, and this is not now about what is in the rules or what is not in the rules, is why are we this concerned about having our records interrogated? Why? Is it because we are people that habitually aid and abet these things? Or is it because there's a real concern around the issues of confidentiality or not? If you receive money, for instance, in cash, a certain amount of money, or you don't do your due diligence well around, or your customer due diligence well, what does that have to do in any way with client confidentiality? So I think that there's a lot of hypocrisy. So I look at the rules of professional conduct. I ask people everywhere. So if Mazi is saying, for instance, to people, go and read the 2003 rules of 23 rules of professional conduct, it tells you where we are in Nigeria. How many lawyers have actually read those rules of professional conduct, the rules that actually regulate them? I'll give you an example. Those same rules of professional conduct stipulate that for a lawyer to practice in Nigeria, he should have made X amount of credits and he'll be issued with a practice license. All of us are still practicing law in Nigeria. Nobody has asked the MBA, where's my license, or have I met these requirements? So why would society take us serious when we observe our own rules in the breach? Thank you.
Thank you very much, Mr. Erojikwe. So I'll be going back to Mazi Osigwe. You know, we talk about, I think the problem we have in the legal profession cannot really be divorced, completely from the problem we have in the country, and in the course of this session, we heard people talk about we have these problems because no sanction attaches to bad behavior, and I completely agree with that. But what do you think? Don't you think that the senior members of the bar have actually not really set very good examples, to the younger ones to follow? And in what way do you think, were you to be, and I want every other member of the panel, except for my lord, to answer that question as well, that the NBA can actually take charge to set good examples, ethical, we talked about ethical behaviors and all that. And of course, it leads to this money laundering issue as well. So in what way can the NBA, were you to be at the helm of affairs, for instance, what will you do differently to ensure that lawyers are, more better behaved than we have at the present?
Thank you, Erojikwe. Let me say this.
You have 2 minutes, please.
You can give me 1 minute, doesn't matter.
Okay.
As long as we continue segmenting blaming the seniors, and suggesting that for every bad thing a junior does must have learned from a junior, we'll never get to the root of the problem. It doesn't matter who is involved. We must first of all educate our people and then enforce the laws. But we're a nation that condones a whole lot. I was a prosecutor at the Legal Practitioners Committee. From my experience, when you're prosecuting, why are you doing it now? Allow him now. He has begged now. He has paid. And we're forgotten that a wrong has been done to the society and to a profession. When you say what can NBA do? NBA does not have any statutory role any longer in issue of discipline. Let's not deceive ourselves. Unless we amend the LPDC Rules 2022 to restore the powers of the bar, to investigate and make a prima facie case of misconduct against a lawyer and to prosecute them, we have been written out of the rules. We have no role to play. We must use our various committees and departments to train our lawyers. We must train them on things that are relevant to the profession. We must train them with respect to things they can point their fingers and relate with. We must train them on things that are valid for them to have an ethical practice. Unless we do that, we are wasting our time. We are blaming people. We're not showing good examples, I agree, but the young ones are also coming up with ideas about how to get things done. But because we have weak enforcement unit processes, if you're taking before the LPDC, you may take between 3 years and 4 years for your matter to come to hearing. For the LPDC to even make a prima facie finding and ask you to reply may take up to a year or 2. Then before your matter is scheduled for hearing. And what is the problem? The problem is that we have a single LPDC that hears matters from all over Nigeria. So you live in Kotangora, you live in Meduguri, you live in my village. Somebody complains against you, you must travel all the way to Abuja. And now it has become more onerous because the rules have imposed burden on a complainant to engage a lawyer to prosecute a matter for him. And he must put it in a particular form. We must do away with some of these strictures. We must amend the law to have the panel sit in states or regions. We must have them sit timeless and set timelines for them to hear matters and dispense with them. We must do things that engender confidence. Unless we show our ability to discipline our members as part of the legal profession, the society will not have respect for us. We must stop. NBA cannot do much, but the NBA leadership can drive the process of training our lawyers, ensuring that finding appropriate cases and presenting petitions as an association against errant members will have proof that they have committed professional misconduct. And we must push to amend the LPDC Rule 2022 to restore the powers of the NBA, which is recognized under Section 11 of the Legal Practitioners Act, of making that finding. But we have to work closely with the members of the body of benchers and Chief Justice of Nigeria to get this done. The fight has to end. We must heal the bar and bring everybody together to work for things that move the bar forward. Thank you so very much.
Thank you so very much, Mazi. Mr. Chukwuka Ikwuazom, please. 2 minutes.
Thank you. Can you hear me?
Yes, we can hear you.
Okay. So I agree to a large extent with my brother Mazi Afam Osigwe. You see, self-regulation is a privilege. Not many professions around the world enjoy that privilege. But self-regulation also comes with certain responsibilities. The problem I think we have is that we have enjoyed the privilege of self-regulation without, living up to the responsibilities. One of the biggest problems that I see is that there are no consequences for bad behavior, right? And the reality is, whether we want to accept it or not, in every profession, the senior members of the profession are required, they have an obligation to lead by example, right? If in a profession, the senior most members are behaving badly, it's going to be difficult to get the younger members of that profession to behave in the right way. And I think that one of the major issues we have with regulation of the profession in Nigeria, legal profession, is that there is a sense among many members of the profession that if you're big enough in the profession, you can do anything and get away with it. You know, we all witnessed, things that happened with the Legal Practitioners Disciplinary Committee, where, a young member of the profession was found liable, right? That young member of the profession appealed to the Supreme Court. The Supreme Court held that on a technical basis, the Supreme Court allowed the appeal, but sent that young member of the profession back to the LPDC. It happened with another senior lawyer. His appeal was upheld on technical ground, but he was not sent back to the LPDC. So as long as we continue to give the impression that if you're big enough, you can do certain things and get away with them, then impunity will continue in our profession. And I agree that we need to decentralize the LPDC. It doesn't make sense to have a central body sitting in Abuja that hears complaints against legal practitioners from across the country. And the length of time, if we want to send the message to the public that we are serious about enforcing discipline in the profession, no complaint against a lawyer should take more than 6 months to be determined. It should be determined expeditiously. If that lawyer has not done wrong, then it will be clear that the lawyer has not done wrong. If the lawyer has done wrong, that wrong should be punished. So if we do not do all of that, then we'll continue. And another thing I would like to talk about before I stop is, sorry?
I said very briefly.
Yes. I also think that we need to take another look at the process for giving out privileges in our profession, right? We need to scrutinize people who are getting privileges, whether it is people who are getting appointed to the bench, people who are becoming notary public, people who are becoming senior advocates of Nigeria. Because if within the profession, we create the sense that you can behave badly and still get to the very top in the profession, that cannot engender discipline. So I think it's important, because what you find at the moment is that when we're assessing people for privileges in the profession, the assessments are usually not qualitative, they are quantitative. So you want to be a judge, they tell you need X number of cases. Nobody is looking at the quality of the cases you're submitting. Nobody is looking at even your character, your pedigree within the profession. I think all of that is important if we really want to enforce discipline within the profession. Thank you.
Thank you so very much. Mr. Erojikwe, your intervention, 2 minutes, please.
Yeah, thank you very much, Nike. I've heard what my brothers have said about the question, and I agree mostly with what they've said. Yes, we need consequence management, in order to get things done properly. We need an effective disciplinary procedure and process, because from my experience when I practiced in England, anytime you looked at the Law Society Gazette, you would find that there are various numbers of people who are either being suspended or removed from the role. But then, even in England, the issue of self-regulation became a big question. And that's why for solicitors now, you have a solicitors regulatory authority. But everything about Nigeria, I think we need to think about the fundamentals. My father always told me that it was important that I knew who I was. I do not think that lawyers in Nigeria know who they are. I mean, we are all out in the field today, those of us on this panel, looking for a position in the MBA, to lead the MBA, and leadership presupposes followership. What is the conduct of the people out there towards those who are aspiring? What is the conduct of the people who are aspiring towards the role that they're about to play or they want to play? It's all a mess from top to bottom. And the earlier we tell ourselves that we need a complete reorientation, the better for us. Because you see, what I find is that those who should be the standard bearers of ethical conduct, you don't have many of them anymore. If we are to tell ourselves the truth about the legal profession in Nigeria, we are truly a ridicule, and that's what everybody thinks. And we know it within ourselves, even though when we profess it, people start shouting. But we must have an introspective look at ourselves and tell ourselves that we need to go back to the drawing board and do what is right for ourselves and for the country. Reorientate completely what we do and the way we do it. That is the bottom line. Everything we have said in this conversation, interrogate it properly. We are talking about the people question. The people question. Can we effectively showcase ourselves as people who even understand our ethics and are ready to follow it, and who understand that there's a responsibility and there's an expectation of us from the entire community and from those who are coming within the community? So I think that we need to have that self-assessment. As far as leadership is concerned, anybody who leads the MBA or who wants to lead the MBA must be somebody who has the character and is credible and can speak truth to power and to his members at all times, because the elite always determine the way that any profession or any organization or any country is perceived. Thank you very much.
Thank you so very much, sir. Let me come to you, my lord. You know, when we're talking about the senior members of the bar, you know, sort of, well, maybe not just senior members. Let me just say lawyers generally, because Mazi Osigwe will disagree with me that it's not just the seniors, but lawyers, you know, filing frivolous applications, especially in political cases. You know, of course, in doing that, we have contradictory orders, you know, being given by the courts, you know, and this is also dragging down the reputation of the bench. So in what way, I still want to stay on this ethical, you know, upholding the ethical standard of the bar and of the bench. What do you think, within a minute, you think can be done, you know, to course correct, so to speak? My lord.
Well, thank you very much. Thank you very much. I think the idea of senior members of the bar or lawyers bringing frivolous application, not just in election petition matters, but in all other cases, I think should be punished severely by the Supreme Court, because most of the time, it is an abuse of court process. A matter has been decided over and over again. You have more than 1,000 authorities on a particular issue. Then judgment has been given. Then lawyers will now bring application either to set aside the judgment or to review the judgment. To me, it's a classical case of abuse. There must be an end to litigation, but it's because such things were not being punished. And like my brother, Afam Osigwe, has said, it appears there are some sacred cows in the legal profession who just believe that they can do anything and get away with it. And it appears the politicians too, and some members of the public who are well-to-do, they know those lawyers they will approach in such circumstance. I think there should be sanity. But like Mr. Osigwe rightly said, there are enough room in the rules of professional conduct to punish decisively anybody who goes against the etiquette of the profession and practice. But because we feel some people, we are living in animal farm, some people are more, all animals are equal, but some animals are more equal than the others. That's the situation we find ourselves in the legal profession. It is only those who are poor or have no one to stand up for them that appear to be facing the brunt in the legal practitioner disciplinary committee, like he has said. So let's call a spade a spade. It is the duty of all of us to make legal profession a better haven for all of us, so that things will go well within our society and in administration of justice.
Thank you so much, my lord. So to wrap this webinar up, I'll start with Mazi Afam Osigwe. Just one innovative thing that you think you will do were you to find yourself at the Human Affairs of the MBA to, you know, to provide solutions to the problems that the MBA, the legal profession has. One thing, just one thing.
One thing I'll push, which is also which is more a decade-old position of the MBA, just the whole of the FDIC and NJC. so that the CJN cannot continue to pretend over the work of MDAC and go on to MDAC to consider his own recommendation. We should also reduce the powers of the Chief Justice of Nigeria to appoint new members of the MDAC. We need to streamline the appointment process to the bench and also ensure that the current inbreeding at the bench, where only appellate justice can make it to the Supreme Court, is ended, so that lawyers from diverse backgrounds can align with the constitutional provisions of that those who are participating in the court can serve in the Supreme Court and other appellate courts. We need to open up the space and engender a merit-driven process for appointment of judicial officers. Only then will people take us seriously, and we must deploy technology in the law reporting so that when judges deliver judgment, just like happens in the NICM, within a matter of days, it should be available online. You don't have to be waiting for it to be typed, for it to be corrected. We must make our court work. And even email which NJC has been investing so much money in so many years to make to work, so that we can file and serve processes through SIM. Well, since you limited me to a few suggestions, I've extended it beyond one more. But just to say that we need to overhaul the judiciary, have constitutional amendments, and have practical solutions on ground to make for ease of doing business with our courts and for hearing of our cases. Thank you, Nike, for this process. I'm afraid I will have to exit at this point because I have put down a meeting so I can continue to participate with this in this webinar. Thank you to class of 2003 Law School for inviting me, and I'm glad for the insightful conversation we have had, and to say that we need not only to match our words with action, but to ensure that the conversation goes on for the betterment of society and the legal profession. Thank you and have a lovely day.
Thank you so much, NLS. We appreciate your accepting our invitation and your participation here. And Mr. Erojikwe, one thing that you will do differently, innovatively, to course correct the station of things in the country with regards to the legal profession?
Well, I mean, when you ask about the legal profession, you make it very broad, right? So because you make it very broad, I'll take one that has to do with justice delivery first, and then I'll talk a bit about the bar itself. So as far as justice delivery is concerned, anyone who's been part of the process of either appointments or discipline or whatever of judges would understand that all that the MBA can do in this regard are advocacy issues or fights or pressure group type of things. And for sure, we will be at the vanguard of that. However, there is and I found in the MBA that there have been identified solutions to many problems around the MBA. The problem that you have is a political will and determination to implement. There is a scheme that we call the court monitoring scheme. That scheme was a scheme that we created during the Olabisi administration of the MBA, and worked with Mr. Dr. Tunde Ajibadesi, Advocate of Nigeria, who was chairman of the Shire Committee, and other stakeholders like Conrad Adenauer Foundation, Justice Reform Project, and the rest of them. And we actually took it as part of the Justice Sector Summit, and all the stakeholders, including the judiciary, accepted that it was a need for an effective court monitoring system. We had even deployed a lot of resources in getting technological experts to develop or deploy an infrastructure for the work to continue, right? And all it was about is that the end goal of it was to assemble data and statistics on what happens in our courts, to identify why we have delays, what the cause of the delays are, and all whatnot. But it was also going to be a scheme that would help call out people who behave badly, be they judges or lawyers. And I think that the fact that that scheme has been in abeyance in the last 2 years is a big, complete shame and mess. One of the first things I would do as president of the MBA is to bring back that scheme, because it is one thing that will put the judiciary and indeed lawyers on their toes. We need to have data, we need to have statistics, we need to know who the culprits are, and then start dealing with the problems if they are institutional and not just things that are done by one or two people. Now, when you talk about the legal profession completely itself, I'll ask anybody to read the legal practitioners bill that was drafted during the time of A.B. Mahmood, and Chief Anthony Diwe led the committee that drafted it. I think it's a bill that we need to take very seriously, because it proposes in it a holistic reform and review of the legal profession in Nigeria to bring it in sync with what you have in other parts of the world. I accept that even when we do that, we might not be able to implement it, but I think that this is one of the areas where fundamentally we need to take a complete reassessment of where we are. So I support that bill. I think that we should sit down with the body of benchers and everybody. And those ones that are very offensive, we remove them. But there are fundamental things in that bill that we need to bring into the legal profession, including some sort of diluted regulation to help us to get to where we need to be. Thank you very much.
Thank you so much, sir. Let's see, Ikwuazom. One thing you would do differently were you to find yourself at the helm of affairs of the NBA.
Okay, thank you very much. My colleagues said more than one thing, and I intend to follow after their passion. But on a serious note, if you ask me today, what is the most potent threat to legal practice in Nigeria, I will say that it is the dysfunctionality of the court system, the fact that our court system does not work, right? So if by the grace of God, I become the president of the Nigerian Bar Association, my focus is going to be on addressing the issues that make our court system dysfunctional. And one of them is the process for appointment of judges in Nigeria. It is a very big issue. We need to insulate that process from political interference. We need to ensure that the right people are appointed to the bench. And the starting point is the people that the Nigerian Bar Association itself appoint into the National Judicial Council. Because I accept that relative to the total membership of the NJC, the 5 members that represent the NBA may not be in the majority. But if we have the best and the brightest, the strongest voices we have representing us in the NJC, that I believe can make a difference. So I'm going to pay very close attention to the process by which, and Afam Osigwe made a very important point. You know, the fact that an overwhelming majority of members of the NJC are appointed by the Chief Justice of Nigeria, who also is the chair of the Federal Judicial Service Commission that does interviews at the first level for people who want to become federal judges. You know, that is not an appropriate situation. And we need to, the NBA needs to push advocacy to correct that. Secondly, we need to take a holistic, another view at the process of even electing leaders for the Bar Association itself and ask ourselves the question, does this current process enable the emergence of the best hands we have within the profession to lead the profession? So those are the 2 things that I am going to focus primarily at, if by the grace of God, I get the opportunity to lead the Bar Association. Thank you.
Thank you so very much, NLS, and I thank my Lord, Mazi Afam Osigwe, Mr. Erojikwe, and Mrs. Oduah that had to leave because she's in transit and she had the flights to take. I thank you all so much. I think we've all gained a lot. And well, while we couldn't discuss everything that we should have, because for instance, I want to talk about how come emphasis is placed on election petition cases at the expense of other cases, but because of the time we couldn't really talk about that. I also want to talk about I would have loved to talk about why we still have only paper, stamp and seal, when in this day and age where a lot of transactions start online, are concluded online, and you might not even use any paper at all. Why the NBA, for instance, is not considering the usual, well, I don't know whether they are, but I haven't really heard so much talk about the issue of digital stamp and seal. Is it because there are expiry dates, so to speak, on the stamp and seal? These are things that we have to, consider in order to have the kind of practice, legal profession that we should have in the 21st century, especially in the days of AI, where everything is, a lot of things are done online. But I thank you all for the insightful, the impactful discussion that we've had, and I hope one day we will get to where we're going. So this is the end of today's session. Thank you all so much, and thank you to all the people that attended, that stayed through the webinar, those that asked questions, those that made comments in the chat box. I thank you all, and we hope to see you again in the next quarter. Thank you. So I think this is the end of the webinar. My Lord, you've been wonderful.
Thank